Because one of the things that we'll talk about, we can talk about it, or I can talk about it now. Interrupt me, please, okay? Talk about it now is opening statements, okay? Now, many of you, I think, don't do them. Many of you think the judges don't want them. And some of the judges, in fact, don't want opening statements, okay? I will tell you, being married to a judge who talks to a lot of judges, okay, that brief opening statements which help the judge focus on what are the issues of this case that I need to be paying attention to is helpful and desired by most judges. Some judges are in too much of a hurry. Let's just get on with it. That's fine, okay? Even with those kind of judges, I would still say, Your Honor, I just want to point out a couple of things before we start. Now, why is that helpful? Well, you got 5 different ways, potentially, that there could be abuse against the child, okay? Do you really want the judge sitting there listening through all the testimony thinking, so is this C, or is this A, or is this E, or what is the lawyer trying to prove here? Which one? If you're not clear in your own mind, the judge is probably not going to be clear either. And you figure, well, you know what, I'll fix it in closing argument. Because when I get to closing argument, I'll say, well, this is abuse. It's somewhere, I'm reminded, and Malcolm will remember, and I certainly do, but maybe some of the older lawyers will remember, it was, I think it was Gus Dumay, an old practitioner, and not a very diligent practitioner in Lewiston, okay, who went up to the law court to argue some kind of case, you know, and it was clear that he was losing his argument. And he says to the law court, judges, just throw me a bone, will you? It's like, that's not the position you want to be in, okay, at the end of your case. And so what I would suggest to you is, for those of you who would do E, we haven't even discussed A through D about the child, but for those of you who will do E, and let's say E is the only one, it will be helpful to the court if when you start out you say, Judge, on Mabel's case, we're going to present you evidence that shows that she has been abused under subsections A, B, and E, whatever you want, okay? And that in the child's case, Catherine's case, we're going to show you testimony and evidence and so on that she's been abused under subsection E. Now the judge knows I don't have to worry about D because you didn't mention D, okay? I mean, this assumes that you're not going to go through with D. All I'm saying is the judge has been put on notice, and the judge is going to be thinking, in fact, the judge will probably at that point open up the PA statute, if he or she hasn't done that already, and say, okay, we're talking about these subsections here, let's hear the evidence, okay? And since you've already gone through this analysis here, you know that when you want to present your testimony, or when you want to present your case about A, you just follow the line straight out. You can gild the lily, you can add the icing on the cake, you can do whatever you want to do, but as long as you've done this, you can come back here, okay, assuming you've proved that they were family household members, you've crossed this one out, you cross this one out, and as long as you've crossed those two out, two elements of the cause of action, okay, and I'm oversimplifying PAs here, but 2 elements of the cause of action, you can sit down. You're done, right? Now, most lawyers don't want to sit down, okay? They want to add more stuff and say more things, and that's okay, good, but unless you've done this and this, I mean, it's like playing bingo, okay, where you have to have completed everything in one column. If you haven't, don't sit down, okay? And what you may want to do is say, Judge, can I just have a moment? Okay? And you go back to your list here and you say, did I really ask her the question, you know, that they were family and household members? And if you didn't, or there's any doubt at all, you go back and you ask the question. Questions? Covering a lot of ground here, but I'm the only one talking. Courtney.
Well, I guess I just want to clarify that although it didn't touch upon it in this case, embedded in the PA statute, which is oftentimes a point of confusion for the judiciary and other attorneys, is the class members of stalking and sexual assault who also qualify, who don't have to be household members or family members. And so I think I just point out to the newer attorneys here who may just see that as a pushback they get from the court, because it's elsewhere in the statute. It's not under the definitions of abuse. And knowing where to point to when the court comes back and says, wait, you didn't establish a household member or family member, there's a stalking victim or a sexual assault victim, where do I go to for that? And although we're not getting into the nitty gritty of the statute, I just want to make sure that those here who might get pushed back on that feel confident in replying to the court that it is embedded in the statute elsewhere.
Okay. Do you have copies of the statute there?
We only have the definitions here. I could pull it up.
Section 4005.
Yes.
Sorry again?
It's in section 4005.
Okay.
I can't think of the number of times where I've been, like the judge has said to me, counsel, you haven't established that they're a family or household member. But the crux of the case is maybe they're stalking or sexual assault. And I think, unfortunately, the statute was written poorly and it's elsewhere. So, right. Yeah. So just knowing that those other class members also have standing for PAs, so there's not confusion leading here today.
Okay.
But it goes to show that knowing that one of those elements can be proven, and then sometimes it's easier to show they're family or household members, and you don't have to prove other pieces of it. Sexual assault or stalking are also elements of what they've experienced.
Well, so, I mean, that simplifies things in terms of, okay, you know, it sounds like under that statute, if you're proceeding under that statute, all you have to prove is stalking, right? Stalking by the defendant.
Or sexual violence, sexual assault.
Or sexual assault, right. Okay. That's all you have to prove here. And you have to be prepared. Is there a memo or something? You just do argument with the judge about, don't have to...
The statute, you just have to point to the part of the statute where it exists. It's just not within the definition part.
Well, in that case, what you may want to do in your brief opening is to say, I'm bringing this claim under, and identify the statute, so the judge gets directed to that right at the beginning, rather than have the judge with this nagging thought all the way through the hearing. Well, this sounds like stalking, this sounds like sexual assault, but where's the family member thing, okay? So it may be good to focus in on that. Are there particular judges that give you pushback?
I tend to find them in Southern Maine, it was less of an issue because they're seeing more of those cases, I think just by volume. Also, the statute changed in 2007, and so I think over time, judges have become more familiar with that piece of it, and I haven't practiced in a couple of years doing this work, but I don't know if people are still hearing that pushback from the court as much. But I used to get it a lot.
I'm sorry?
More so from clerks who push back when you try to file a PFA instead of a PFH without being family, household, or dating partners.
Okay.
So it was added into the statute in 2007, and but it was placed elsewhere, so it's not an obvious standing member.
Okay. So if you think there is a risk of confusion, again, if you can simplify things for the judge to make the judge's job easier at the beginning. I mean, each of these hearings is just sort of like an unfolding story if you don't have some kind of direction at the beginning as to what to look for. Hang on one sec. So, you know, I want to, you know, an example from my wife who was talking about pro se, you know, and so you would expect these kinds of things with pro se plaintiffs, that, you know, she tells a story about the pro se plaintiff that comes in and tells this rather elaborate story and goes on and on and on and on. And of course, you know, she's going to listen, you know, but she's waiting for the shoe to drop about when are you going to say something that actually hooks into the statute. And it never came. You know, and so she, after the, you know, an hour of hearing, she then has to explain to the pro se plaintiff, you know, I'm sorry for what's happened to you, but the fact of the matter is you needed to have proved A, B, C, and D. Can you do that? And the woman says no, and says, sorry, can't give you an order. Okay, so you will not make that mistake. You shouldn't make that mistake now, right? Now that you know you've got to prove every single element. You already knew that, but I'm sort of crystallizing that for you. But I'm going to suggest to you that it would be helpful to the judge, not only to identify, that the downest and dirtiest way to do the opening is to say, Judge, I'm going to offer you evidence that shows that there was abuse under sub, pick the letters, okay? The next one, assuming the judge has the patience to hear you and maybe thanks you for being that clear, is to say, the way I'm going to prove A is you're going to hear testimony of ba 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 ba. The way I'm going to prove C is you're going to hear testimony of ba 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 ba. Okay? Judge is going to like that. Judge is going to make a little note that says A is going to be proven by these 3 ways. Now, you better prove them, with those 3 things. And even if you don't, as long as 2 of them are enough, okay? But if you've prepared your case, you know that you're going to have those 3 things there to prove A. Questions? Yep.
I had a question about opening, general opening. I don't know if we can talk about this more, but I like what you said about the roadmap in the beginning and getting everybody on the same page. If we're going to have some request for some creative relief at the end, do you think it's a good idea to give the judge a heads up about that in the beginning, or wait till the end?
Oh, I would say at the beginning, if it's something that just sounds like it's, because whether you're a judge or you're opposing counsel or whatever, you're going to have to then, if something new comes up at the very end, you're going to have to sort of replay in your mind the whole trial. And it's like, well, what do I have that fits into this category over here? So I think the fewer surprises you can have for the judge, and I understand that you may consider that to be tipping your hand to opposing counsel. Okay? All right, so you got to weigh that back and forth. And Judge, I'm going to ask that the defendant not have any firearms. If that shouldn't be news because you checked off that box. Okay, but and Judge, we're going to have discussion about the defendant's use of firearms in the house. Okay, and threats to use firearms and things like that. There in like 12 seconds, I've kind of primed the pump for that. And so if you're going to ask for extraordinary relief, you may want to also, so the judge doesn't immediately push you back like, that sounds crazy to me, say, because Judge, you're going to hear testimony about boop, boop, and boop. Okay? And if that's going to be enough to get the extraordinary relief, I think it's better to flag it at the beginning than have the judge think, yeah, because, whether we want to admit it or not, whether judges want to admit it or not, they don't make up their mind at the end, always, okay? As they're going along, they're saying, okay, this is where this case is going to go because they've seen this case like 7,000 times before. Everybody thinks their case is unique. It isn't, okay? And so they say, this is the order I'm going to write at the end, just like I did yesterday on such and such a case. And so if you want something unusual to occur, you're better off getting the judge thinking, well, this might be a one-off kind of thing. Okay?
I was just going to put a point out there as far as being cognizant of what seemed to be obvious facts or elements. The first race discrimination case I had, it was really obvious that the plaintiff was black, and I was going through the whole thing, and I was like, oh, I actually don't have in the record him testifying as to his race, that that's going up there as an element of, and so it's obvious to everybody in the room,
right,
this really important element of the case, and so just being cognizant of things that may seem obvious to people who can see the testimony, but it, on paper, on appeal, it doesn't read well, it doesn't translate well, or you're missing something if you're trying to point to parts of the transcript.
Yes, I think that's a great point in terms of how do you make the record, because you always have to assume that either you or the other party will appeal. Okay, and if the record is devoid of anything, then the appellate court isn't going to know that you've checked off that box. Okay, and that would definitely be a box. Easy enough to do. Can you tell us, please, what your race is? Have them put it right on the record. Okay? So, More questions? Yeah, Frank.
The other thing I would say, as far as openings are concerned, the best thing that can happen for you, because you're going to do a ton of these during the course of your career, right? You're going to be in front of this judge a lot. You're going to be in front of you in court a lot. The best thing that can happen to you is if you do a really concise, good opening. Don't waste the judge's time. But the best thing that can happen to you is if at the beginning of the hearing, the judge says, I don't really need this instinct, and I don't really need, kind of rolls your eyes at you. But at the end of the case, the judge says that was really helpful. And so once you prove to the court that you're helpful, then you kind of get the benefit of the doubt the next time you're in the court. So you just need to be really concise, and you need to make sure that if you say something in an opening, you're going to be able to prove it, right? You don't want to overpromise in the opening. You want to be really, you want to respect the judge, you want to be really to the point. You know? And so I remember one time, and this is not an opening, but doing a redirect, and the judge kept saying to me, you understand it's got to be really narrow, it's got to be just on this, and she did not believe I could ask that question. And when I asked that question, I actually heard her say, oh, that is the redirect question. And every time I was in front of that judge again, the judge would give me the benefit of the doubt that I knew what I was doing.
Yeah, I think that's a really important point, Frank, and one of the things we'll talk about, the reason you have notebooks there, okay, is for those of you who don't use trial notebooks, okay, we'll talk about preparing a trial notebook, and it's part of that same impression you're trying to create with the judge, that when the judge sees you walk into the courtroom, the judge is going to say, I know this lawyer is organized, this lawyer is not going to waste my time, the court's time, okay, this lawyer is going to help me make a decision. That's what you want. Okay, and certainly, you know, if you can, in fact, get in your brief, and I mean brief, just sort of give the judge a roadmap of this is where we're going, okay? Doesn't have to be elaborate. You don't have to be arguing the case, any of that kind of stuff. It's going to be helpful to you, and it'll be helpful to you the next time that you appear. Okay, more questions on this? I'm going to leave this topic here of working on the elements. Yep.
If you haven't been invited to give an opening statement, how would you suggest you request one?
Your Honor, could I briefly address the court about what the proof is going to be? And I know the court's time is valuable. I'm not planning on wasting any time, but I think it may help the court. May help the court if I could just be given 2 minutes. You can time me, Judge, if you want. 2 minutes, just to sort of lay out for you where we're going to go with this case. Okay? And that's not just PFAs. That's, you know, anything. Okay? And the judge may say, you know what? I've heard 1,000 of these, and it's like, all right, you know, that's fine, your loss, okay? But the real problem is going to be, you know, if you're going to ask for unusual relief, at the end, you know, you should be arguing to the judge, you should have let me open, okay? Because I would have warned you that we're going to take a left turn somewhere along the line here. So, but also keep in mind, judges talk. Okay, you think that the judges kind of work in these silos. They don't, okay? And so you do a good job saying, you know what? Courtney gave this, you know, really 3-minute opening statement that really kind of helped me focus in on the case. Other judges are going to hear that, okay? But more importantly for the group of you, okay, is that the judges hopefully will say, oh, I've got a Pine Tree lawyer here. That lawyer is going to help me understand this case and get to the end of it, okay? I mean, that's really what you're looking for. You are a law firm, okay? And you are looking for the brand to be appreciated by the judiciary when any one of you walks into the courtroom. And the only way you do that is by each one of you doing impressive work. Okay? All right. So,